Hi, I'm Michelle Schuster.
And I'm Chad Blackham, and welcome to Compliance Talk. So today we're going to start off with a very interesting case with some pretty wide-ranging implications. A new case out of the 7th Circuit, Steidinger v. Blackstone Medical Services. Now, what started off as a pretty typical TCPA case, Telephone Consumer Protection Act case, relating to allegations of unwanted text messages received in violation of do not call restrictions, automated technologies, is very familiar verbiage to anyone who's involved in the space. What started as a very regular case took a very interesting turn, as the court ultimately held that a text message does not qualify as a telephone call or voice communication under the TCPA and its associated regulations. So the court ultimately found that the defendant was not liable for sending the text messages. Now, before I get into a little bit of the analysis with this, I would caution that this ruling is only limited to the 7th Circuit and limited to the specific facts at play here. So if you aren't in that area and you don't know those facts, this is not something you should be relying on whole cloth. But it is very interesting because it comes against a contrary ruling from the 9th Circuit about a month or so ago, holding that text messages are telephone calls under the TCPA. Now, the analysis here is a little bit interesting. The TCPA was passed in 1991. The first text message commercially wasn't sent until the following year. So the argument being the definition of a telephone call could not possibly have encompassed something that was not known and did not exist at the time. The 7th Circuit has apparently agreed, finding that text messages are not telephone calls under the TCPA and finding for the defendant in that case. So we now have a circuit split on the issue of whether text messages are telephone calls under the TCPA, and potentially a Supreme Court case, maybe some certiorari coming down the road. But this is absolutely a very large, major issue that will need to be resolved, and I would not be shocked if we see other circuits taking more divergent views, or maybe some action from the Supreme Court in the coming months.
Yeah, it's a really interesting case, but really the message to all of our clients is we still need to treat text messages like phone calls. The unfortunate reality around all of this is that there are a lot of plaintiffs' attorneys out there, and they are more than happy to file these lawsuits, maybe not in this circuit, but in others. So it's a best practice to continue to treat text messages like phone calls. I have something not nearly as interesting as that, although I find it interesting. So the FCC, in its open meeting last month, passed a further notice of proposed rulemaking that has to do with their robocall mitigation database. And the RMD's been around, gosh, probably for about 2 years now, maybe a little bit more. And the RMD, or Robocall Mitigation Database, its purpose is to require all voice service providers to file a robocall mitigation plan with the database. If you're a voice service provider and you do not have a robocall mitigation plan in the database, then you can have all of your calls not accepted by your downstream provider. So really important for those of you in there that you have a good robocall mitigation plan and on file with the database. The types of things that are required in that are a know your customer process. So you have to give a detailed explanation of how you know your customers. Also, you have to have a robocall mitigation plan that details how you are preventing robocalls, illegal phone calls, from being made using your voice services. And when we talk about robocalls, there's not really a great definition of that. I would say a robocall is an artificial pre-recorded voice or one that violates the do not call laws. I think that's a good rule of thumb for having effective robocall mitigation processes in place. What's interesting about this, though, and what is going to cause a lot of companies issues, especially those that are more information services placed or a dialing platform, the FCC is saying in this new rulemaking that you will be considered a voice service provider and that you will be required to get something called an SPC token. And that SPC token is going to have some ramifications if you're required to get one, because you have to file to get your 499A filing, which requires you to submit an application that could have implications for paying into the Universal Services Fund. So in order to get the SPC, you've got to get your OCN number, you have to register with another federal agency, and it is likely to have some tax implications. So before going ahead and filing with the robocall mitigation database or getting your SPC, make sure you consult with legal counsel so you know the full implications of what could happen with a robocall mitigation database filing.
Absolutely. In switching back over to something tangentially related, also kind of in the realm of cyberspace, but back to the litigation arena, this might be something a few of you have heard about as well, the very large T-Mobile data breach ruling that came down recently. So for those of you who are not aware, T-Mobile is recently accused of violating privacy laws in Washington and failing to provide proper notice of a data breach. Significantly, the court ultimately was examining whether T-Mobile committed a total of 722,000 violations in total. Very, very large number. There were approximately 360,000 that they doubled due to various violations. Now, what's significant about this are a couple of aspects I'd like to highlight. The first, and potentially the most important, is that this is yet again another example of state enforcement of privacy laws rather than at the federal level. The case was brought by the Washington Attorney General, and significantly, on a motion for summary judgment, the Washington Attorney General won, and T-Mobile was found liable. So T-Mobile is now seeking reconsideration of that ruling. We don't have a definitive path for relief or what's going to happen to T-Mobile, but this does show that state attorney generals are continuing to pick up the slack despite the lack of federal legislation in this arena. And it also goes to show the importance of proper data breach protocols and protections. A lot of the violations here are actually stemming from a failure to properly notify consumers, not necessarily the breach itself. So your kind of retrospective compliance efforts are almost going to be considered just as important as those proactive ones, hoping to stop these types of breaches from happening in the first place. So absolutely massive data breach case, completely controlled and initiated by state attorneys general, something we've been seeing a lot of in the past. A little interesting because we're out of Washington instead of perhaps California or other more familiar territory. But this is something to watch for in other states with significant privacy laws such as Illinois, California, and the other ones coming down the pipeline like in Virginia and Connecticut. So definitely something to be wary of even in the absence of federal legislation. And now, having said that, it looks like there might be some federal legislation relating to children's privacy laws coming down the pipeline as well. But recently we have seen several versions of privacy legislation aimed at protection of children's rights pass the Senate, in particular 5 different bills that incorporate 13 other bills provisions. Now, given the number, I'm not going to go through all the uniquities of these particular proposals, but some major highlights are that most of these would apply to all businesses that run websites and interact with children. Now, this is distinct from something like COPPA, the Children's Online Privacy Act, where it's really aimed at businesses who are targeting or marketing towards children. These are much more broad-based. Some of the basic requirements are aimed at more technology-based companies, those that use chatbots or automated decision-making, providing full disclosures, and actually banning the use of individuals under 18 in some bills and under 13 in others from using these advanced AI features. Now, nothing to really be too concerned about now, but what I think is interesting too is that these bills are kind of folding in the concept of AI and automated decision making into something that might be inherently dangerous to children. So for those of you who are using chatbots, automated systems, AI and automated decision making really in any capacity, even if your websites are fully aimed at adults or even B2B, these might be something to watch coming down the pipeline. You might need to include new disclosures or opt-out provisions for individuals under a certain age. So more compliance obligations potentially coming down the pipeline, something to watch for, but unique because it affects all businesses, not those that are necessarily focused solely on children.
Yeah, it's a big change. And then just one last thing, if you are interested in filing comments on the FCC's further notice of proposed rulemaking regarding the robocall mitigation database, it has been, that notice of proposed rulemaking has been filed with the Federal Register, so there are 30 days from, I think it was July 22nd that it was filed. So end of August, if you're interested in filing comments with the FCC, it affects you. I highly recommend that you do. Thanks for joining us today.